My name is Kristen York, and today I am presenting Discrimination Law and Education for Education 7040, the Teacher and the Law. Discrimination is a vast and constant plight in education and the world around us. It is a prejudice. It is thinking of a category instead of the individual. Some synonyms include segregation, bias, just, unjust, inequitable, just to name a few. This video is For the Birds by Pixar. I felt it truly encompassed discrimination in a way that can prompt discussion across all age groups. Discrimination is a concern because of its prevalence. Discrimination can be against poverty, religion, age, sex, ability, and race. I have seen discrimination in my gifted referrals. I have seen discrimination in discipline. Both of these have long-standing consequences. These two TED Talks speak on diversity, access, and inclusion, belonging, a critical piece of diversity, equity, and inclusion. Both are very informative and present a different perspective. These are some of the legal aspects: 1964 Civil Rights Act, 1972 Title IX, 1975 Individuals with Disabilities Education Act, 2015 Every Student Succeeds Act, and Title I. The Civil Rights Act fulfilled the promise of the 14th Amendment. It ended things such as Jim Crow and separate but equal. In 1972, Title IX prohibited sex-based discrimination in any federally funded programs such as education, athletics, and employment. 1975 Individuals with Disabilities Education Act provided free and appropriate public education to students with disabilities. This included an individualized education plan that provided services to prepare each student for further success. In 2015, Every Student Succeeds Act and Title I replaced No Child Left Behind. Its goals were to provide equitable access to funding and resources for disadvantaged youth, to provide high-quality preschools, and to hold schools accountable for any academic gaps. The first case that I studied was Sheff versus O'Neill. This case began in 1996 and was settled in 2006. The problem was the state of Connecticut had an average of 25.7% minorities in their public schools. Hartford had 92.4% minorities in their schools. The districts were drawn in such a way that the city schools and the suburb schools were completely separate. The Connecticut Supreme Court ruled that this was unconstitutional and had to be corrected. The state provided the solution of charter schools and magnet schools in order to increase diversity and desegregation. This video, Sheff versus O'Neill, is about an hour long, but it is incredibly informative, and I highly suggest watching it. Raleigh versus Board of Education is the second case that I studied. This case began in 1982. It was about disability discrimination. The problem was that Amy Raleigh was a deaf student who had accommodations and an IEP. She had services such as a hearing aid, a tutor for the deaf, speech therapy, a teletype machine, and administration had been trained in sign language. The parents also wanted a sign language interpreter in all academic classes. This accommodation had been made for a brief period the year before, and the team concluded the service was not needed. The ruling was that FAPE is already being achieved through the current IEP. Amy was able to participate and successfully engage in all academic content. The resolution was no further accommodations needed to be made. FAPE requires services in order for students to be successful, and Amy was being successful without any additional resources. I hope you have enjoyed my presentation on disability. discrimination, in education. I look forward to learning with you again.